Good morning, everyone. Thank you all for coming. And for those of you who do not know me, my name is Mark Herring. I'm the newly minted Attorney General of Virginia. With me is Cynthia Hudson, Chief Deputy Attorney General, and Stuart Raphael, Solicitor General. In 1 week, a federal judge in Norfolk will hear arguments in the case of Bostic versus Rainey. Timothy Bostic and Tony London live in Norfolk. They've been together as a loving and committed couple for 25 years. Janet Rainey is Virginia's Registrar of Vital Records and the individual charged with enforcing our state constitutional ban on marriage between same-sex couples. The other two plaintiffs, Carol Shaw and Mary Townley, live in the Richmond area. Their relationship of 3 decades was formalized in 2008 in a marriage in the state of California. Together they have a 15-year-old daughter. These two couples want Virginia to recognize their love and commitment. From that recognition, they would derive obvious benefits, such as hospital visitation, basic parental rights, and clear survivor benefits. They would also derive the enormous intangible benefit of societal recognition. I believe the freedom to marry is a fundamental right, and I intend to ensure that Virginia is on the right side of history and on the right side of the law. Today, I have notified the United States District Court for the Eastern District of Virginia of a change in Virginia's position in the case of Bostic versus Rainey. After thorough and independent review, I have concluded that Virginia's ban on marriage between same-sex couples violates the due process and equal protection clauses of the 14th Amendment to the United States Constitution. As Attorney General, I cannot and will not defend a law that violates Virginians' fundamental constitutional rights. And accordingly, in light of next week's scheduled argument, the Commonwealth will instead side with the plaintiffs who have brought this case and side with every other Virginia couple whose right to marry is being denied solely on the basis of their sexual orientation. This decision is based on my analysis of the law and my duty to fulfill the obligations of the Office of Attorney General. There are those who will say that the Attorney General is required to defend every challenge to a state law, even a law that is unconstitutional. They could not be more wrong. There is solid precedent for my actions here today. To defend a law that I have concluded is unconstitutional after a thorough legal review would be a violation of my oath, a misuse of the office, and would be inconsistent with the precedents established by prior Virginia Attorneys General. Former Attorney General Cuccinelli refused to defend the Opportunity Educational Institution last year after determining that it violates the Virginia Constitution. He was right to do so. Former Attorney General Jerry Kilgore joined with 43 other state attorneys general in 2003 to argue that an Attorney General is properly carrying out his constitutional duties when he seeks to invalidate a state law that he believes, in his independent judgment, to be unconstitutional. In that brief, Attorney General Kilgore and the other attorneys general said, when an Attorney General believes a statute violates the Constitution, he has a paramount obligation to defend the Constitution he is sworn to uphold. The brief also said, while the Attorney General is obligated to represent state officials and agencies to the best of his abilities, he need not, indeed must not, do so at the expense of the people as a whole. To do so would be an abdication of official responsibility. Even conservative jurists, such as Robert Bork, John Roberts, Justice Scalia, have agreed that this is the appropriate role of an Attorney General. Therefore, having determined after thorough, rigorous legal analysis that an unconstitutional law is infringing on the rights of Virginia families, I have a duty and the authority to act to protect them and their rights. But my decision today does not mean, I want to be clear about this, it does not mean that the case will end, nor does it mean that the ban will go undefended or unenforced until the courts can rule on the matter. The State Registrar, Janet Rainey, will continue to enforce the current ban, but neither she nor I will defend its constitutionality. Counsel to the clerk of the court in Norfolk Circuit Court and a national law organization representing the clerk of the Prince William County Circuit Court will remain in the case and continue to argue in favor of the legality of Virginia's ban on marriage rights for same-sex couples. This will ensure all sides of the argument are presented to enable the courts to render a decision. Even as courageous Virginians have advanced the cause of equality, the Commonwealth of Virginia has too often argued on the wrong side of our nation's landmark Supreme Court cases. With Prince Edward County as defendant in the landmark school desegregation case of Brown versus Board of Education in 1954, with the Commonwealth fighting the right for Mildred and Richard Loving to marry, despite their race, in 1967 in the Loving decision. And in 1996, to oppose opening VMI to female cadets. The same legal principles that applied in those cases apply in this case today. As a legislator in 2006, I voted against the right of same-sex couples to marry. Even at that time, I spoke about the need to fight other forms of discrimination against Virginians based on their sexual orientation. But I was wrong to stop short of marriage equality. Like millions of Americans, I've thought hard about the issues involved, including the legal issues. And I have talked with my family, with friends, co-workers, and constituents about the human impact. And since I have spoken publicly about how my views have changed and how I have arrived at a better, more inclusive place. But I want to be clear that my decision today is not based on my policy preference for marriage rights for same-sex couples. It is based on my thorough analysis of the applicable law and the constitutional questions raised by this case. Virginia is in many ways the cradle of democracy. Washington, Jefferson, Madison, Mason, Monroe, and others called our state home. And America's first freedom, religious freedom, was written into law just a few steps and blocks away from where we stand. As Virginians, we have much to be proud of. But too many times in our history, our citizens have had to lead the way on civil rights, while their leaders stood against them. This will not be another instance. It's time for the Commonwealth to be on the right side of history and the right side of the law. Writing for the majority in 2003 in the Lawrence versus Texas case, Justice Kennedy explained for the court that the Constitution's framers, quote, "New times can blind us to certain truths and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress." That is certainly the case here. And I will fight to end this oppressive ban and to guarantee the constitutional freedom for loving couples to marry in Virginia. That is because of the oath I swore when I took office. That is my paramount